A very good afternoon to you and welcome to In Focus with Silvana Pavlovska, broadcasting from Melbourne, Australia. We're continuing our series dedicated to the Macedonian question and in particular the scholarly publication of Professor Dr. Igor Janev titled The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity towards the termination of an illegal treaty. In the last few weeks, we have covered 5 of the chapters contained in this publication. A publication by Professor Dr. Igor Janev, as I said, an eminent, renowned author, expert on international law. Today, we're going to start chapter 6. Now, chapter 6, I already mentioned in the previous broadcast that it does contain the conclusion and some final recommendations from the professor. In the present book, that is this publication, we have analyzed political and legal aspects related to sustainability and legality of the PRESPA agreement, or PA, as it is known as well, concluded between Macedonia and Greece on 17th of June, 2018. We started this research with analysis of the legal grounds of the PRESPA agreement and particularly aspects of the United Nations Security Council resolutions 817, 1993 and 845 from 1993, in which, in quotation, the name dispute in quotation was imposed on Macedonia as a framework for conditioning during its admission to the United Nations membership, especially conditions: 1, to accept a provisional denomination, the former Yugoslav Republic of Macedonia, the FYROM, for use within the system of United Nations only, and 2, to negotiate the state's name with a country that did not recognize it at all. We have argued, says the professor, that the imposing of additional conditions in the Security Council Resolution 817 to an applicant state after affirming that the applicant fulfills the admission laid down in Article 4, Paragraph 1 of the United Nations Charter is in severe violation with the advisory opinion of the International Court of Justice of the 28th of May, 1948, accepted by the General Assembly Resolution 197/3 of 1948, as interpretation of the Article 4 of the United Nations Charter. In view of these 2 United Nations documents, the Security Council Resolution 817, 1993, is a blatant breach with the UN Charter Articles 1, Paragraph 2, Article 2, Paragraph 7, and Article 4, Paragraph 1, the first 3 belonging to jus cogens norms of international law. The Security Council Resolution 817 is therefore an ultra vires act by the United Nations, violating the peremptory norms of internal law, and as such cannot serve as legal basis for the PRESPA agreement or for any other treaty according to general legal principles ex injuria jus non oritur. In our research, we found that the origin of an imposition the illegal framework for negotiations defined by the UN Security Council resolutions 817, 1993, were absence of essential knowledge of the representatives in the UN Security Council in 1993 who did not know that additional conditions to the generally prescribed enumerated conditions in Article 4 of the Charter could not be laid down to the applicant state. In the Macedonian case, this candidate state applied to the UN membership with its constitutional name. Okay, those of you who want to check that, you can see United Nations document S/25147. The UN Security Council resolutions 817, 1993 reported that all conditions related to the article were met. All conditions were met, and still imposed despite that, they imposed additional political conditions with respect to diplomatic recognition, arbitrary, that formally transcend in time the moment of admission of the applicant to the United Nations. Therefore, additional and arbitrary political conditions with respect to prior diplomatic recognition created as an effect additional illegal obligations, degrading the membership status of Macedonia, that finally, after dubious negotiations over the ID, resulted in the legal PRESPA agreement, the harmful act endangering the very survival of the Macedonian state and nation. Members of the United Nations Security Council in 1993 didn't at the time realize that a dispute between two states may not exist under international law and over the state's ID, and as a final consequence of their ignorance emerged the PRESPA agreement, the Compromise Act for actual nullification of the national identity. PA appears to be at the same time an illegal treaty and illegal treaty in blatant violation of jus cogens norms and basic rights of a state, and also acts in sharp violations and disrespect for human rights. Furthermore, the United Nations Security Council in 1993 essentially didn't realize that under international law, a state does not have the exclusive right over their state's name, and that the state's ID is the crucial and an inseparable legal element of the judicial personality that could only be a subject matter of recognition or not recognition, not of a dispute. On the other side, or on the other hand, the Macedonian government, the president, and the diplomacy did not understand or know any or all of those essential principles, and in fact implicitly accepted with no reason, or no reaction, I should say, with no reaction, disgracefully unlawful United Nations extra conditions imposed on Macedonia in the process of its admission to the UN. Both the UN Security Council representatives and the Macedonian diplomats, including the Macedonian president himself, actually have not observed or noticed or knew a principle that the state's name or any change of it do not affect the territorial or other rights of a state, nor create the rights or obligations of other states, vis-a-vis the others with that name. The main Greek argument of alleged Macedonian irredentism is in quotation, against Greece was in fact rejected by the International Court of Justice in 2011. Refer to judgment of the ICJ, Macedonia versus Greece, 2011. You can check this yourselves. Based on apparently fake grounds, yeah, the Greek diplomacy successfully persuaded members of the UN Security Council that the applicant state with its name conducted a policy of irredentism. A same argument, or rather fake ground, later rejected by the ICJ 2011 decision. In addition, what Macedonian diplomats didn't realize at that time was that a chosen state's name could not be linked or affected by any historical political rights, since the historical political rights as an arbitrary category does not even exist in the modern international law. Apparently, unprofessional Macedonian diplomats were naively persuaded by skillful Greek diplomats on the importance of the historical narrative and needlessly started endless irrational negotiations over its name due to the lack of knowledge of international law and insufficient international experience. Even after delivering the legal opinion of the Badinter's Commission that only the Republic of Macedonia, opinion number 6, and the Republic of Slovenia were states capable for international negotiations, Macedonian diplomats in 1992 started naively and needlessly negotiations over the Macedonian national name under EC auspices, like some historical issue existed between the two countries that needed to be resolved. Rather, incompetent and amateur Macedonian diplomacy didn't explicitly refuse to negotiate over the name, that is an ID, capital I, capital D, even in the United Nations as a non-negotiable subject, and as a consequence of their fallacy, UNSC Resolution 817 was born. So they allowed for this resolution to be created as partially illegal document, example with illegal additional conditions embedded in it. Hence, absence of the basic legal knowledge and fallacy by the Macedonian government and its implicit consent for illegal negotiation framework didn't legalize the UN resolution, did not legalize the UN resolutions and its legal effects, since illegal acts do not create law. Illegal acts do not create law. Ex injuria jus non oritur. For those of you who understand Latin, I don't, but I'm assuming that's what it means. I trust the professor would know these things. From historical perspective, it should be noted that the chosen modern state's name per se actually may not necessarily be even linked to the antique or any historical period at all. These simple historical facts as ancient names or designations have no relevance from the point of international law whatsoever, says Professor Igor Janev. Needlessly to discuss, but even simple recent facts prove that the Macedonian nation was not artificially created in the 20th century, as the Bulgarians would argue, but much, much earlier, at least from the period of immigration of when all these people moved to the Balkan Peninsula. So the Greek argument that this new candidate for the UN membership may not use their antique name sounds ridiculous and misleading. Nevertheless, in the absence of understanding with respect to conditioning for UN membership and motivations of the Hellenic Republic, members of the Security Council have voted unconsciously for an illegal negotiating framework enshrined in the United Nations Security Resolutions 817, 1993, and then confirmed that by the United Nations Security Resolutions 845, 1993, same year, 2 resolutions in the UN, 817 and 845, were that the state was actually stripped, the state of Macedonia, the country of Macedonia, the nation of Macedonia that we've known from the very beginning, when we came to be on this planet. The state was actually stripped from its legal ID, that is the state's name, after the entrance to the United Nations. Furthermore, UNGA Resolution 47/225 was also partially illegal, imposing negotiations on new sovereign member state over its legal identity with the other state that does not recognize it, calling even other UN members for collective non-recognition. My goodness. It should be noted that the UN organization is an association of sovereign member states linked by a treaty, that is the UN Charter. Okay, we know it as the UN Charter. The members with equal sovereignty in accordance with the UN Charter, Article 2, Paragraph 1. Apparently, the state's legal identity is an essential and inseparable element of the international judicial personality of the legal person, such as a state. Please see AJIL Volume 93, Number 1. And the sovereign judicial personality as an inviolable category. That means matter strictly in domestic jurisdiction of the sovereign, a state where no external interference is allowed. Thank you, Professor Dr. Igor Janev. We're going to stop there. So this has been chapter 6 of the book, The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity. This chapter, which deals with the conclusions and the final recommendations by the professor, we are dividing into several parts. So this is part 1, as I said. Please stay tuned for part 2, which will be coming up shortly. You've been watching In Focus with Silvana Pavlovska, broadcasting from Melbourne, Australia. Today is the 19th of April, 2024. Looking forward to seeing you shortly.